My name is Jonathan Block. I'm CEO of Exchange Data International, which is a data vendor which has been going for 27 years, operated out of London, UK, with the bulk of its customers both in the UK and USA. And we provide reference data, corporate action, and closing prices to a large percentage of the financial community.
I'm Andrew Martin. I'm a copyright consultant. My background in this goes to the early 90s when I ran the Canadian Copyright Licensing Agency. For the last 15 or 16 years, I've worked as an independent consultant. And just before we began this interview, Jonathan and I reminisced that, in fact, we'd started talking about some of these issues in his office in 2008. So there's a long history to what we're going to cover today.
Well, firstly, we commissioned it because these are issues of vital concern to everybody in the financial community. What we have found over the years is that certain providers of data, including the exchanges, have adopted monopolistic practices which in many ways contravene antitrust laws and intellectual property laws and believe that they can get away with it. So we commissioned this report to look at the overall legal contextual basis of their claims.
I mentioned that Jonathan and I started having these discussions over 13 years ago, and the context, I think, is that in the early 2000s, exchanges started to move more towards a commercial for-profit model. And so they began to look at ways in which they could monetize what had up till then been fairly normal parts of their regular activity. We began, as I say, looking at this in 2008 when there were some indications that trouble was on the horizon. The white paper that we're talking about today really builds on several years' work as a number of cases covering different aspects of intellectual property and database protection have come before the courts. And we think we are now at a point where really the direction is absolutely one way in terms of how the jurisprudence is trending. And this is what we cover in the white paper. Yes, certainly. Well, very basically, what we think is that exchanges are selling things that they don't own. We've drilled very deeply into this question, and we've looked at what a closing price actually is. It can, in fact, be a number of things, but it all comes down to this. It is not in any way an original or creative output. And that being the case, it cannot be the subject of copyright. And if it can't be the subject of copyright, our position is that exchanges cannot exert their control over the production of closing prices in order to levy unreasonable charges. There's an also underlying subtext, which in fact we looked at early on in these discussions, which is if there was copyright in closing prices, not only don't the exchanges own it, but probably the companies whose stock it is would be the owner. But that's really irrelevant because what we're saying is a closing price is essentially a statement of fact. It's a detail. It cannot be the subject of copyright in any country. As far as database protection is concerned, that is more complicated. The answer is basically the same on either side of the Atlantic, but you get there through a slightly different route. What the exchanges are saying is that even if closing prices themselves cannot be copyright, they do a huge amount of work to create databases of closing prices. Our position is that that's simply not the case. These are lists. There might be compilations of lists. That has implications in the US, for instance, but these are unoriginal facts. Very little work goes into a database of closing prices beyond what exchanges are obligated, sometimes statutorily obligated, to do anyway. So our bottom line is they don't own the copyright and they aren't entitled to any kind of database protection either side of the Atlantic.
Sure. So the problem with competition law is that the exchanges are often in a monopoly position in the sense that they are the only providers of this data. And in many cases, they use this power to extort either extortionate fees and or very onerous contractual terms. And Andrew would be best to explain what this means in the legal context.
The basis of our complaint here is that often by statute, certainly by convention, exchanges are, as Jonathan said, the only providers of these data. They are using their gatekeeper role in order to essentially try and monetize their core activity. They're trying to make money from the licensing of data, which they're required to produce anyway. They're coming up with all sorts of sort of sleights of hand to the effect that even if they're required to provide closing prices, these closing prices become historic data soon after they're released. And what we say is that this actually contravenes antitrust law on both sides of the Atlantic. They are required to produce and distribute these data. They're trying to extract money. They're trying to impose unreasonable licensing terms. They're basically, at best, subsidizing the activities they're required to undertake anyway. And worse, we think they're trying to make a profit. We understand that for the last 2 decades, this has been the mission of many exchanges. But what we say is that you cannot do this in relation to data where you are the monopoly provider and often where you are required by law to provide these details. Yes, basically exchanges, we say, are breaking the law. We're not saying that they're criminals. We're saying that they are claiming ownership in something they don't own, that they are using their database activity in order to prevent people from accessing material that they're supposed to make available. And when they do agree to license it, they're charging unreasonable amounts of money and placing unreasonable restrictions on how the data can be used, including, for example, requiring any third-party end user to contract directly with the exchange or to agree to terms that the exchange has imposed and to pay more money. So the short answer here is we think the exchanges are seriously offside. That's the history of the white paper. It's been 12 or 13 years in the making, and we think that the exchanges need to be called up on what they're doing.
Yes, I think the hour has now come for people to look at the models in the financial system. What was previously acceptable is no longer acceptable. And it's very interesting that so far you've had 3 regulatory authorities, IOSCO, ESMA, and the FCA, looking at the whole issue of market data. And this matter is not going to rest until there are changes. Thank you. Please visit our website, www.exchange-data.com, or alternatively email us at info@exchange-data.com. We look forward to hearing from you. Thank you.